In 2006, federal law enforcement opened a case against Jeffrey Epstein. It was thorough on paper. Agents collected testimony, conducted interviews, built a file. But the search warrants themselves were narrow. They targeted only specific years, 2002 through 2005, then separately 1997 through 2001. Those time windows meant investigators looked at fragments, not the full picture. 2 years later, in 2008, Epstein struck a deal. He entered a non-prosecution agreement, a legal structure that allowed him to plead guilty to lesser charges while federal prosecutors agreed not to pursue broader investigation. The courts issued protective orders alongside that agreement. Those orders were absolute. They legally sealed the investigative material. No one could see those files without a court's explicit permission. For 15 years after that agreement, those documents sat locked away. The FBI had collected them, the courts had secured them, but the public couldn't touch them. No journalist could request them, no victim's attorney could examine them in full. The institutional machinery had done its job, gathered evidence, preserved it, then made it invisible. This wasn't conspiracy or malice in the traditional sense, it was bureaucracy functioning exactly as designed. Courts protect confidentiality. Prosecutors follow agreements. The system works. But the outcome was silence. Millions of pages about a trafficking network, sealed behind legal authority. That's the baseline. That's what exists before anything else happens. FBI Director Kash Patel would later acknowledge this himself, calling it the original sin of the Epstein case. He admitted the search warrants had been limited, that the 2008 agreement had locked doors that probably should have stayed open. He said if he'd been director then, it wouldn't have happened that way. But he wasn't, and the files remained sealed. Until they didn't. Senator John Kennedy of Louisiana didn't approach the moment theatrically. He wasn't performing outrage, he was executing procedure. During the Senate Judiciary Committee oversight hearing on September 16, 2025, he had a specific question prepared and he asked it with the precision of someone who had reviewed the available record. His setup was matter of fact. You've seen most of the files. He wasn't speculating. Patel, as the newly appointed FBI director under the Trump administration, had access to the Epstein investigation materials as part of his mandate. Kennedy continued, who, if anyone, did Epstein traffic these young women to besides himself? The question contained its own architecture. It acknowledged Epstein as an abuser. It asked about distribution, about the network. It was the question that logically follows if you've reviewed sealed investigative files about a trafficking operation. The word besides himself wasn't rhetorical padding, it was precise, because trafficking, by definition, involves moving victims to others. And if the FBI had spent 15 years investigating Epstein, if agents had interviewed victims and compiled evidence, then someone in the Bureau should know the answer to that question. Kennedy's tone didn't carry accusation, it carried expectation. This is a senator asking the FBI director a straightforward institutional question. You've reviewed the materials. What did you find? The phrasing itself was almost cordial, almost, but there was steel underneath it, the kind of steel that comes from knowing exactly what question you're asking and understanding that the person answering has already seen the answer. The transcript captured it. C-SPAN recorded it. Multiple independent sources documented the exact exchange. What happened next would define everything that followed. Patel's response was immediate. Himself, he said. Then, there is no credible information. The word choice mattered. Not no information exists, not we found nothing. He said no credible information. The distinction is subtle but significant. It opens a logical door. If there is no credible information, the implication follows there is non-credible information, information that exists but doesn't meet a threshold, information that was reviewed, categorized, and rejected. Patel continued without pause, as if anticipating the question before Kennedy could ask it. If there were credible information, I would bring the case. I would prosecute it myself. It was a statement of institutional commitment, a promise that the FBI would act if evidence warranted action. But he didn't elaborate on what he'd actually seen. He didn't describe categories of evidence or explain the review process. He didn't say, we reviewed X number of documents and found Y. He offered conclusion without exposition. The hearing moved forward. Kennedy didn't press. Other senators asked other questions about other matters: the Charlie Kirk assassination investigation, personnel changes at the FBI, political weaponization claims. The Epstein exchange lasted perhaps 90 seconds. It was registered, noted, and then absorbed into the larger testimony. But something structural had occurred. Patel had just testified under oath that he'd reviewed the Epstein files and found no credible trafficking information beyond Epstein himself. He had positioned himself as willing to prosecute if evidence existed. He had established a clear boundary, credible versus non-credible, and then he'd moved on. The incompleteness of that answer wouldn't matter until months later, when context would shift everything. But in that moment, in the hearing room, the exchange concluded. Patel's statement stood: no elaboration, no clarification, just a refusal dressed as an answer.
2 months after Kennedy's question, President Trump signed the Epstein Files Transparency Act into law, November 19, 2025. The legislation was direct. The Department of Justice would release investigative materials related to the Epstein case. No more sealed files. No more protective orders shielding documents from public view. The machinery began. More than 500 attorneys and reviewers from the Department of Justice worked through the archive. They pulled documents from 5 primary sources: the Florida case, the New York case against Epstein, the case against Ghislaine Maxwell, investigations into Epstein's death, and multiple FBI investigations spanning years. On January 30, 2026, the DOJ released the first massive tranche, over 3 million pages, 2,000 videos, 180,000 images. The official statement from the department was careful in its language. It noted that notable individuals and politicians were not redacted in the release of any files. Translation: if your name was in those documents, the public would see it. The BBC reported hundreds of mentions of Trump scattered through the files. References to someone called the Duke, unidentified, unexplained. There were also admissions buried in the DOJ's own press release. The department acknowledged that the production included fake or falsely submitted images, documents, or videos, material that citizens had sent to the FBI over the years, making claims that couldn't be verified. The chaos was institutional. Files existed. Some were real, some were fabricated. All were now public. 4 days later, on February 3, 2026, advocates for transparency filed new complaints. They claimed documents were still being withheld, that selective redactions continued, that the release, despite its scale, remained incomplete. 3.5 million pages had been published, but somewhere, advocates insisted, more existed. More remained locked away. The question that Kennedy asked in September, who did Epstein traffic to, was now suspended in a different context entirely. The answer wasn't a statement from Patel anymore. The answer was now a public archive that millions could search themselves. Kennedy's question never received a direct answer, not from Patel, not from any official statement. What happened instead was displacement. The question moved from the hearing room into the public record. It became something viewers could investigate themselves. Patel had testified under oath that no credible information existed about trafficking networks beyond Epstein himself. Then, millions of pages entered public access. Those pages contained material Patel had reviewed, or material he hadn't. Either possibility creates tension. If he'd reviewed those files and still said no credible information, then the answer stands as given. Incomplete, perhaps, but official. If the files released later contained information he hadn't reviewed during his preparation for the hearing, then his statement was accurate but narrow. A technically true answer to a question about a larger archive. The advocates claiming continued withholding suggest a third possibility, that even now, even with 3.5 million pages public, the full picture remains unavailable, that selective redactions and institutional resistance persist. The structure of this situation is what matters. Kennedy asked a reasonable question. Patel gave a measured response. Then the facts became public, accessible, searchable. The burden shifted. The FBI director's testimony is now one data point among millions. It can be checked against the archive.
It can be verified or contradicted by documents that didn't exist in public view when he spoke. The question isn't what Patel said anymore. The question is what viewers find when they look, what they discover in those files, what they make of the gaps, the redactions, the unidentified references. Kennedy opened a door. The DOJ published the contents of the room behind it, but the room is vast, and most people haven't entered yet. The answer to his question is now distributed across millions of pages, waiting to be assembled by anyone willing to search.